Good morning. Welcome to the Board of Vocational Nursing and Psychiatric Technicians, May 18, 2023 board meeting. My name is Carol Mountain. I'm the board president. I would like to call this meeting to order at exactly 9 o'clock. First, some housekeeping information on how this meeting will be conducted. As the agenda shows, the board will conduct business over today and tomorrow, Friday the 19th. We will take public comment on each agenda item. Members of the public who request to speak will have up to 3 minutes to speak, and you will be notified when you have 30 seconds remaining. Your name is not necessary, but please indicate how you would like us to identify you. For the sake of efficiency, the executive officer may respond directly to public comment or defer to the appropriate staff person or counsel as appropriate. For any questions directed to board members, I will either answer the question or direct it to the board member as appropriate. We will now do an alphabetical roll call to establish quorum. We have a new board member, Gloria Guzman. She was appointed to the board on March 23, 2023. Welcome to the board, Gloria. Please introduce yourself and let the board know about you. Gloria?
Hello, thank you. My name is Gloria Guzman. I'm a licensed vocational nurse. I've been licensed since 1986, and I'm excited to be here. And thank you so much, everyone.
Thank you. Did you say Ms. Brown is not here yet?
That's corrected.
All right, we'll move on to Ms. Carpenter, Alita Carpenter.
Yes.
Mr. Durking, John Durking.
John Deerking is present, and welcome to Ms. Guzman.
Thank you.
Abraham Hill.
Abraham's present. Welcome, Ms. Guzman.
Thank you.
Ken Maxey.
Kenneth Maxey present. Welcome, Ms. Guzman.
Leslie Moore.
Good morning, present, and welcome, Ms. Guzman.
Thank you.
It is Ms. Needless. Is she on yet? I don't see her.
Do not see her.
Okay. Rashima Sonson.
Yes, good morning. Rashima Sonson is present, and welcome, Ms. Guzman.
Thank you.
And I'm Carol Mountain, and I'd also like to extend a welcome to our new board member. Thank you so much for joining us.
Thank you.
We will now move to agenda item number 2, introduction of the board staff. Ms. Yamaguchi.
Good morning, everybody. Thanks so much. And we're fired up and ready to go. With us today, our ADO, Mark Ito, our enforcement chief, Antoinette Wood, our SNEC, Beth DeYoung, managers, Jay Prouty, Shelley Brown, supervisor Mike Hall, a vast amount of NECs, Judith McLeod, Faye Silverman, Charlene De La Rosa, Jessica Gomez, Tara Davila, and I'm gonna steal Miss DeYoung's thunder. Our brand new NECs, Roberta and Mary. Also, we have analysts Nicholas Gonzalez, Geraldine Marcino, Christine Dano, and of course Rebecca Ball steering the bus. Council.
Good morning, everyone. Ken Swenson, General Counsel for the board.
Christy Shields, Regulations Counsel for the board.
Thank you so much for the introduction from both Ms. Yamaguchi and legal counsel. I believe we are now ready to move on to agenda item number 3, legislation and regulations. Committee report, Ms. Carpenter.
Yes, good morning. I apologize. When you were calling roll, I just responded yes. I thought you were going to ask me a question, but yes, I am present. The Legislation and Regulations Committee. Madam Chair and members, we met on Wednesday, April 12th. Myself and Rashima Sonson were in attendance, as well as staff and council. Ms. Yamaguchi updated the committee on the legislation and regulations portion of the current strategic plan and suggested that this item be placed on the next committee agenda for an update and for future work. Ms. Yamaguchi reviewed the bill tracker grid, which is in your packet, containing the current legislation being followed. She briefed us on some of the bills that staff has been watching. She shared details about Senate Bill 544 Laird, which codifies the governor's executive order during the pandemic, allowing state boards and commissions to continue holding virtual meetings without being required to list private addresses of each remote member or providing public access to private locations. This bill achieves the goals that were contained in AB 1733 quirk of last year, which we supported, but which was never heard. As of Monday, May 15th, Senate Bill 544 passed the Senate floor and is waiting to be assigned to committee in the Assembly. It has had strong bipartisan support, and staff is optimistic that the bill will move quickly. As for rulemaking updates, staff and council provided updates on several pending regulations. Senate Bill 1436, respiratory care. RCB has not scheduled a hearing for its proposed regulations, for which BVNPT filed a comment, and it voted at its March 9th meeting to pursue new legislation regarding the training and provision of respiratory care by LVNs. This bill has not yet been introduced. We plan to work with RCB on the training component whenever RCB is ready. Assembly Bill 1536, new school program approvals. Staff and council have been working to produce a certificate of compliance and make updates to the forms to be included in the rulemaking package. Senate Bill 994, naturopathic doctors. Staff and council are working to develop a sample supervision protocol for supervising naturopathic doctors to use when hiring LVNs. CCR Article 5. These represent the regulations regarding the approval and oversights for the LVN and PT programs. The Education Division is working on the proposed language for these. And this concludes my report, Madam Chair. And Ms. Yamaguchi or I would be glad to answer any questions that you have.
Thank you so much. When you go through the report, I realize what a busy year or so we've had. Pretty amazing. Ms. Yamaguchi, do you have anything else to add to that?
No, Madam Chair, it was a pretty good thumbnail sketch of the meeting. Thank you, Ms. Carpenter.
Thank you, Ms. Yamaguchi.
Are there any other questions or comments from the other board members? Ms. Yamaguchi or council, do we take comments from the public at this time?
Always good to take comments.
All right, let's take comments from the public.
This is the moderator. We've opened the Q&A panel. If you'd like to make a comment on the item that was just discussed, please click on that Q&A icon on your screen, typically located in the right corner. Looks like a question mark inside of a square. You can type the word comment into the text box and send that to our panelists. If you're a call-in user, you may also raise your hand by dialing *3. We will take comments in the order they are received. And as a reminder today, we will be limiting comments to 3 minutes, and you will receive a 30-second reminder when your time is about to expire. And at this time, I do not see any requests for comment. Would you like me to close the panel?
Yes, please, and thank you. So we will move on to agenda item number 4, enforcement, report, recommendations, and possible actions. Mr. Maxey, chairperson, Ms. Moore, board member.
Madam Chair, I think, pardon me, I think we need to take action on some of the rulemaking. Council Shields. We had noticed a couple.
Correct. I mean, there's actually another item under item 3, Madam Chair, if you look at sub D. I know we kind of went through the legislative and regulations report quite quickly, and you didn't actually take discussion. At least there was no discussion on the other items that are listed under 3. But if you look at D, can we go to D on the screen? Is that possible?
There we go.
D.
C.
Right.
There we go.
So I don't know I guess the report covered A, B, and C, is that correct? Or did you have in mind that the board would discuss those legislative items within that report?
Madam Chair and Council, it was my thinking that unless there were questions or comments, we would go directly to item D and do the business here.
Okay. All right.
Let's move forward with item D.
So you want me to start, Ms. Yamaguchi?
If you wouldn't mind, thank you.
Okay. So you received the materials in your packet regarding this item. This is consideration of changes to previously approved text. And the text involves the rulemaking that we're trying to enact permanently, the regulations for new school approval processes for schools of vocational nursing and psychiatric technicians. So if you look at the memo in your packet, it discusses the background involving the legislation, Assembly Bill 1536, and the fact that you were given authority to adopt emergency regulations for a period of time until permanent regulations could be adopted. So we have done the emergency regulation approval process. That regulation authority, however, is due to expire on June 27th, 2022. So we're in the process of trying to make those regulations permanent. And so those emergency regulations have been in effect for nearly a year now. And during that time, staff have discovered some issues and are requesting that there be some additional changes to the regulations that were proposed under emergency and now through the regular rulemaking process. The regular rulemaking process was noticed on March 10th. We did not apparently, according to staff, receive any public comment during the public comment period, which ended on April 25th. But notwithstanding, the staff, as I've indicated, did believe that they've gotten some informal feedback while they've been administering the emergency regulations that went into effect last year. And so we're bringing before you some suggested changes to text and forms. I know it looks like a lot, but they're basically cleanup changes for easier comprehension, correcting inconsistencies with existing regulations. The largest change is to the letter of intent. So just for our new members, the process for school approval includes an initial filing of a letter of intent, which sort of lays out the prospective proposal the school plans to implement before they file an application. And once they file the letter of intent, that includes certain elements, then they're notified of when a nursing education consultant would be able to review their application, and the application is then filed. So in the letter of intent that was originally proposed, we had two separate processes. One where a written narrative statement was submitted along with a one-page letter of intent that simply includes personal information, the name of the school, the program, contact information. And so the big takeaway from that was that the applicants really didn't like the written narrative statement information to be in a separate regulatory section of the proposal. They wanted all the information to be placed on the form. So if you look at attachment D, which starts on page 41 of your attachment B as in boy, it starts on page 41 if you're looking online at the information, and you can see that there all of the text, you can see page 40, can you, yes, thank you. Keep going, a couple pages down, actually to page 43, if you could.
And this is just, as this is the moderator, and just so that everybody's aware, since these are full page documents, if you'd like to see lower sections on the document, each individual user will need to scroll down on their screen. As the presenter, when they scroll their screen, it will not show the same for everyone.
Okay, So you can see here that the main modification here is that we've taken all the information that you see listed below and we placed it says as required by Form 55M1. We placed all of that information that was listed below, like the philosophy of the program, the conceptual framework, requirements. Those are now on the form. So if you go to the forms, they start at page 117. I know it's a bit of a jump. Thank you. You'll see, if you could just keep scrolling down, maybe 118. Thank you. You can see that those requirements were moved to the form. And so we placed those on the form because the complaints from the applicants were that they didn't know where those requirements were and they didn't know how to look up the regulations. So the staff believed that it would be simpler to put that information on the form so everything's in one place. So we did that both for the vocational nursing school applicants and also at 55M1 and for the psychiatric technician applicants for 56M1. And the rest of the changes, I mean, we've covered in the memo. They're mainly typographical cleanup changes. There were a couple additional changes. If you go, can we go back to the memo on? Thank you. There were some additional changes to things like the number of daily lesson plans that need to be submitted, and the rest were mainly typographical updates. But is there anything that was set forth in the memo or in the text or the forms that the board members had any questions about? But so all the changes again are in double underline and double strike through. But we also kind of replicated that in the memo, so it'd be easier for you to find. But you can, look at the documents themselves as well. We've attached those. Any questions on those changes?
Questions? Moderator, do you see any questions?
I'm not seeing any hand raises from our members or staff.
Okay, so if there are no questions, the motions are on page 17 of the memo. So if there are no issues with those changes and the board agrees with the recommendations from staff, then page 17 of the memo, then the motion would be to approve the proposed modified text as provided in attachments B and D and direct staff to take all steps necessary to complete the rulemaking process, including sending out the modified text for an additional 15-day comment period. If after the 15-day public comment period, no adverse comments are received, authorize the executive officer to make any non-substantive changes to the proposed regulations and adopt the proposed regulations at Title 16, California Code of Regulations, sections 2525, 2526, 2580, 2581, 2537.2, and 2590.2 as provided in the modified text notice.
So moved, Alita Carpenter.
John Deere King will second.
And then we will take public comment on that.
This is the moderator. I've opened the Q&A panel. If you'd like to comment on the motion before you, please click on that Q&A icon on your screen. Type comment into the text field and submit that to our panelists. If you're a call-in user, you can raise your hand by dialing *3. And I'm not seeing any requests for comment either through the Q&A or hand raises at this time. Would you like me to close the panel?
Yes, thank you. Shields, is this time that we would do a
Vote.
roll call vote?
Yes, please.
Thank you. Did Ms. Brown make it? Is she here?
Here.
Oh, wonderful. Ms. Brown.
Yes.
Thank you. Ms. Carpenter.
Yes.
Mr. Durking.
Yes.
Ms. Guzman.
Yes.
Thank you. Mr. Hill.
Yes.
Mr. Maxey.
Yes.
Ms. Moore.
Yes.
Ms. Nieblas, is she here?
Yes.
Thank you. Ms. Sonson.
Yes.
And I am also a yes. That carries unanimously. Thank you so much for your excellent work on this and your report, Ms. Schlieg.
One more update. Just want to let the board members know that we'll probably be extending the emergency until the Office of Administrative Law, which is the agency that looks at and reviews your regulation proposals, acts on it. So we'll be extending it until we get word on their action on this current proposal. So just wanted to let you know about that. Thank you.
Excellent. Thank you so much. Are we now ready to move on to item number 4? Enforcement report, recommendations, and possible actions. Mr. Maxey.
Yes, good morning, everyone. So the Enforcement Committee is excited to update the board on its recent work. As you may know, the disciplinary guidelines and uniform standards related to substance abuse document has not been updated since 2011. The committee had requested that it be updated and has reviewed the changes made in the document. It was determined by the committee to bring that document to the full board for discussion and possible action today. I will now refer this item to the board's regulations counsel, Christy, for an overview of this for this item. The actions needed to begin the rulemaking process to make the changes requested in the proposal, and for further questions the board may have on this item. Christy?
Good morning again. Sorry, having trouble with my video there. So for the new members' benefit, I just want to quickly go over the fact that the disciplinary guidelines are a very important document. That document becomes a regulation when in the regulatory proposal in the text, you'll see that the board says it adopts it and incorporates it by reference. So that means everything in that document become a rule, a standard of general application that are supposed to be followed in every case, but can be deviated from in certain, based on the facts of the case. And so, but it is the document you would be using to review your enforcement matters, your statements of issues, your accusations, where a statement of issues is for applicants and accusations are for those that have a license already, but it would guide you in your decision-making process. So it's important to evaluate the document, and where you see underline and strike through, those are proposed changes. Where it is not underlined in the document, it is existing guideline rule. So the proposal would be to retain it. So where it's not struck through or underlined in the document, that's the recommendation of staff is to keep it. And as Mr. Maxey indicated, this document has not been updated since 2011, and a lot has changed. The laws have changed, your regulations have changed, and that guideline document has not kept pace with it. So it needs to be updated to reflect changes in laws and regulations, but also what you and your staff have seen on an ongoing basis in your cases. You know, policy decisions and positions may have changed since 2011, and So there was an attempt here to make changes consistent with how things are being worked out in the enforcement environment. So the largest changes, you'll see changes throughout, but the most significant changes have to do with adding new criteria, rehabilitation criteria, and mitigation criteria. These are the factors that you would use to decide whether you should, lessen the penalty that would normally be imposed for that type of violation, and the evidence you would consider going forward. And so I think that it's important that the board members review the document, have reviewed the document, and are comfortable with what is being proposed. I'm not going to go through every section of the document, but if you have any questions and you'd like me to review them with you and discuss them with you, please let me know. So I'll open it up to the board members at this time. Any questions, concerns?
Question, this is Board Member Maxey, just making sure that, is this something that you would like us to vote on today, or is this something that we have time to look over as board members? What is the request today?
Well, the request is that you vote on it today so we can begin the rulemaking process to make those changes. So yes, the goal would be to initiate the rulemaking process, and unless there were adverse public comments, we would proceed to implement as proposed in this document.
Thank you.
So if there's anything in the document that you would like me to go over with you that you have concerns about, now would be the time to do that. Anything?
Say, if I may, this is Elaine. Mr. Maxey and members, this by no means would be the last time the board would see this language and have the ability to make comments or add input. So this is the authorization for the staff to start that process.
Well, it wouldn't come back, the way the motions read, it wouldn't come back to the board if there were no adverse comments. So we would have to change the motion to require it to come back at the end of public comment period. But typically, if the board is comfortable with the proposed text, then we would proceed through the rulemaking process to adopt the text under that delegation in the motion on page 6 of the memo. So my question would be to the board members, do you have a concern with any of the changes that are being proposed?
I don't have a concern. This is Carol Mountain. I would really appreciate some clarification on what this means. It says, change the optional taken past the licensure examination condition to ensure that they include information on the reinstatement of a license and the use of the new proposed model orders. Can you just explain to me what the change would look like? I'm just not sure I quite understand that.
Okay, this is just a summary. So I would recommend we need to go to the document itself in the take and pass licensure exam. Let's see, where is that in the document? That would be on page 40 of the Adobe version online. I don't know if you can go there.
Yeah.
Okay, great. So if you look at the underlined part of this term and condition, it says, if this condition is intended to precede issuance of the license, this is for a statement of issues. So for the new members, when we have an application that contains possible grounds for denial, then the executive officer issues a denial document called a statement of issues, where we're outlining what violations or grounds for denial may exist in the application. And so sometimes when the board is considering an applicant's qualifications, there may be an issue with competency. And so there may be a situation either for a statement issues or someone that's returning to licensing after being revoked, where you want them to show proof that they can take and pass the licensing exam, because maybe there have been some issues in the application process where you've learned that they can't, that they may not be competent. And so what they call this is a condition precedent. So it would say in the order, for instance, that prior to issuance of the license, the applicant shall take and pass the licensure examination within 2 years from the effective date of the board's decision, as you see here in the existing text. And so what we're saying is we would like person that's writing the order for the board to use the model language in this section, grant application and place license on probation after completions of conditions precedent. So what that means is, please go to the section of this guideline and use this language so that we can have consistent orders that implement the board's intent. Because what we've seen over time is administrative law judges may not write the orders correctly. And so what they'll do is they'll say the board issues the license and then they take the exam. But what we really want them to do is to take the exam first, pass it, and then they get their license. And I know it seems like that should be common sense, but it doesn't happen. Often we have administrative law judges writing the order, as I've indicated, as a condition subsequent, meaning it happens after the license issues. We don't want that typically, because we want to make sure you can pass the exam, because if you can't pass the exam, you shouldn't be practicing. And so that is true of people that are applicants. And if you go down a little bit further on the page there, we can scroll down a little bit. Shelley can, or somebody who's doing the driving here. I'm not.
This is the moderator. I've scrolled down, but I believe, as indicated earlier, I think you have to scroll down because of the
Oh, I do. Oh, okay. Sorry.
Yeah.
I'm the least technologically proficient person in the room, probably. So anyway, so see how it says reinstatement? So, perhaps you have someone that's been out of practice for 15 years. And you say, well, let's just be sure that they still know what the minimum standards are. So let's make them take the exam before they reinstate their license. Again, we have the same problem with administrative law judges saying that the board issues the license, then they take the exam. No, we want them to take the exam and then get the license. So this is directing the administrative law judges to use this language, but also use the model orders when granting the petition and placing the license on probation. So I know that's a lot to digest, but that's the main thrust of what we were trying to explain. It's kind of hard to summarize all of that in a memo. But then the next part of that proposal is that, that they don't resume practice until we notify them that they've passed the exam. So I know, again, that seems like common sense, but it's not in there right now. And so people, if they find a loophole, will drive the truck through it. So we want to make sure that that all the potential loopholes for probation administration are covered, and we don't have people resuming practice until they've received notice that they've passed the exam, that taking and passing the exam is a condition preceding the issuance of the license. So that's what why that section was changed.
That helps me immensely. Thank you so much for that excellent explanation. It really does help.
Welcome. Any other pieces in the memo that everyone's like, I don't know what that means?
So based on the my colleague's silence, do I call the question for a vote, or would that be from
Well,
Ms. Mountain?
let me also, if you wouldn't mind, briefly, if we could, I'm trying to find where it is in there. Rehabilitation. I want to go over that really quickly with you. The rehabilitation criteria. No, for some reason, I'm not finding it in the document here.
It looks like page 37.
Thank you, Ed. Okay, so if we could go there really quickly, page 37. Okay. Oh, wait. No, that's the addictive behavior. Sorry about that. Let me see here.
Could it be rehabilitation evidence on page 57?
Yeah. Let me see here. Okay, so if we go to page 57, correct, thank you. Actually, let's go to page 55 first, if you wouldn't mind. So here's some big policy items that were added here that I want to just bring to your attention. The first one below is evidence and aggravation of penalty. So if you look there, the things that you consider when you're determining whether the minimum or the maximum penalties in the guidelines should be applied, you think about, in your particular case that you're reviewing, whether there's evidence in aggravation, mitigation, or rehabilitation. Aggravation is something that you would consider increasing the penalty towards the maximum range when these criteria potentially occur. So these were things that your staff has identified as potentially increasing a penalty. So things like failing to take responsibility, evidence that the violation was knowingly committed or was premeditated. And can we go to the next page? Or do I do that, drive that? Okay, thank you. If the violation was committed against a vulnerable person, including the developmentally delayed, those with cognitive impairments, elderly children, or incarcerated person, or those whose physical limitations made the violation easier to commit. If the violation was a physical or sexual assault against a vulnerable person, they violated the rules and procedures of a secure detention facility, state hospital, prison, juvenile hall, or jail, such as smuggling of phones, drugs, or other prohibited items to persons in custody. They have a history of prior discipline, particularly where the prior discipline is for the same or similar type of conduct. Respondents' actions resulted in financial damage to their patients or other consumers. The amount of the loss may be an additional aggravating factor. They violated board probation, or they've committed conduct constituting unlicensed activity after the surrender or revocation of the respondent's license. So that would be something for someone who's petitioning for reinstatement. That would be a criteria for that. And then evidence that the respondent has not cooperated with the board's investigation, the duration of the violation, so the length of the violation, evidence that the respondent knew or should have known that their actions could harm their patient or other consumers. And then the last one was that they took advantage of their patient for personal gain, especially if the respondent was able to take advantage due to the age or lack of sophistication, understanding, or knowledge of the patient. So these are, I'd say they're pretty standard. There are, of course, some differences in your criteria based upon the consumers that you serve in the jurisdiction you have here. So anything in there that anyone has any concerns about, these would be factors you would consider. They don't always apply in every case, but they may be considered. Any questions on those? Okay, and then here's another section, evidence and mitigation. So evidence and mitigation is evidence that tends to lessen culpability or severity of the proposed penalty. And mitigating circumstances include convincing evidence of rehabilitation. You have regulations that set forth what the rehabilitation criteria are. So we're saying we need to use those rehabilitation criteria when looking at whether the penalty should be reduced. Demonstration of remorse, demonstration of corrective action or plan to prevent recurrence, because it's not just the fact that there's been a violation, but whether they're continuing to be a threat to public protection. That should be a main consideration in enforcement cases. Whether the violation was corrected without monetary loss to consumer or restitution was made in full. If the violation involved the conduct of multiple parties, the relative degree of culpability of the respondent should be considered. So any concerns with those criteria? Okay, and then I suggested adding this to the guidelines rehabilitation evidence because I know, and I think your staff have confirmed that people will often ask, well, what would you consider? What can I submit to show that I am rehabilitated? And I think it's a good idea. It helps people understand what the board is looking for, and also would reduce the amount of calls potentially that you get from affected stakeholders who may want to know what types of rehabilitation the board would consider. Now, it doesn't always mean that the board will consider it complete rehabilitation, right? So these are just examples of what you would consider. Doesn't mean that you would always accept it in every case as being proven. You're still going to be, investigating and inquiring potentially. If you have a petition for reinstatement at a hearing, you get to ask those questions about whether these statements and evidence are credible, right? You still get to evaluate that. But I think it's very helpful to your staff and, like I said, the regulated community to know that these are the types of examples of rehabilitative and competency-based evidence that they could submit and you would consider. Doesn't mean you're going to accept every time, but so the first one is performance evaluations, acknowledgement. Sorry. The first one is recent dated. First one is recent dated written statements and performance evaluations from persons in positions of authority who have on-the-job knowledge of the respondent's current competence in the practice relevant to the disciplinary proceeding, because it could be a psychiatric technician or a vocational nurse, including the period of time and capacity in which the person, sorry, I'm trying to go to the next page here. Work with the respondent. These statements or performance evaluations should include an acknowledgement of the allegations in the accusation or statement of issues to ensure the evaluators a clear understanding of the issues. So again, part of the credibility evaluation is if someone's saying they recommend someone for, mitigating penalty or reinstatement of their license, you evaluate whether it's credible if they don't know that the person has a history of violation. So that's why you have them a recommendation here that they include an acknowledgement that they know about, their past history in that recommendation they provide you. And then we ask this signed under penalty of perjury because they're submitting basically a sworn statement to you. And we ask that they include that verification certification there. Then another example is recent dated letters from counselors regarding the respondent's participation in a rehabilitation or recovery program, which includes at least a description and requirements of the program, a psychologist's diagnosis of the condition and current state of recovery, and the psychologist's basis for determining rehabilitation. recent dated letters describing the respondent's participation in support groups from their sponsor, recent dated laboratory analyses or drug screen reports confirming respondent's abstention from drugs and alcohol, recent dated physical exam or assessment reports by a licensed physician confirming the absence of any physical impairment that would prohibit the respondent from practicing safely, recent dated letters from probation or parole officers regarding the respondent's participation in and or compliance with terms and conditions of probation or parole, which should include at least a description of the terms and conditions and the officer's basis for determining compliance, recent dated letters from persons familiar with the respondent in either a personal or professional capacity regarding their knowledge of the respondent's character, the respondent's rehabilitation, if any, the conduct of which the respondent is accused, or any other pertinent facts that would enable the board to better decide the case. Such letters, again, signed under penalty of perjury. Recent dated completion certificates for education courses related to the grounds for discipline or denial in the accusation or statement of issues. So education is often a something that the boards accept in consideration of whether their person who's involved in the allegation has maintained competency and shows that they're professionally staying current within the practice. Any questions about that? Oh, there's one more, sorry. Any other information respondent would like to submit that shows respondent has worked to correct any unprofessional conduct or deficiencies charged in the accusation or statement of issues. So that one's sort of a catch-all. We're trying to give people examples, but we're not going to say these are the only examples of rehabilitation evidence the board can submit. They can submit to the board. So we're giving people sort of this catch-all to allow any evidence that they would like to provide that they can. That this gives them that clarity in that notice. Any questions on
Appreciate
that?
the clarity, and I think it'll help as people know better what to submit and what we accept. I think this makes a lot of sense.
Thank you.
I have a question.
Okay.
About this section about providing evidence. It is helpful. My question to that is, I understand that it may or may not be considered by the board and it's in good faith of the individual, but in regards to providing evidence, is there like a minimum? Like, is there just two, or you could just provide one to be sufficient? I'm just curious in regards to if they are going to provide evidence, is one okay, or should two be the number?
Well, we can't really set a number because it's going to depend on the facts of the case and the type of violation we're talking about. If it's a competency violation, you're going to want to see evidence that, that they've taken educational courses, that they've stayed current. And so it will depend on the violation. It'll depend on the individual facts of the case. So I think what we're telling people is look at your violation, look at this list and see what you think makes sense for you to submit. And these are just ideas for what people can submit, because we've had trouble with people knowing what will be accepted. And so these are commonly accepted types of evidence that I've seen with other boards in the department that have been accepted. And I think Ms. Wood and I tried to tailor it to your particular profession as well, these different criteria. But I don't think there's like a magic number we can put down, because it's going to depend on the facts of the particular case. What makes sense for them to submit. And I think we're just trying to give them some guidance, because I know the staff get phone calls, like, when people get a denial letter or they get an inquiry about, typically the letters will go out saying, we've identified this issue with your application, or we've identified this issue, we are investigating. And then people will say, what can I submit to show you that I've made progress in my rehabilitation? And there's no place to point to. So I think naturally the boards have started putting this list in here so people can get an idea and a feel for the types of evidence. But there may be other things, like maybe they go and take the licensing exam on their own and they say, hey, I passed the exam again, I'm competent, you know, that's another form of evidence, right? That you might consider. But I think the reason we put it here was because that is something there's a frequent question about. And this is something that in your staff's, in my experience, that the board has considered and accepted in some cases. Whether you think it should be accepted based on evaluation of that evidence will be up to you in your discretion. But we were just wanting to give people some guidance because I think this is a very confusing process for a lot of people and they don't know. We don't want to hide the ball. Of course, we want to know what the truth is. And so we try to give people as much help as possible, but they have to make their own case to you, to your satisfaction, that they're rehabilitated. Because if they're rehabilitated, they don't need to be disciplined. They don't need to be barred from practicing, right? Or they maybe have a lesser penalty because they've shown progress and you just want to monitor them for a little longer to make sure they continue in that progress. But if we don't give them any kind of guidance, I think my experience has been we don't really get to the bottom of where they are in terms of their practice and rehabilitation. So I think it will help hopefully your cases going forward to have that. For your staff as well, they can just say, look, here's the list the board has put out. Look at that list and see if anything makes sense for you to submit. Does that make sense?
Yes, it does. Thank you.
Okay, great. Thanks. And the last thing I wanted to cover is just the model orders we were talking about a bit earlier. So you see the different types of orders that you can issue. One is for revocation when you don't think there's any rehabilitation proven at all. So that's an example of what that order would look like and what, you know, direction we're giving them when that happens. If we go to the next page, then we have revocation stayed. So that's what a probationary order looks like. When you decide to place someone on probation, this is how it would look. It would have the license type, name of the respondent, and that it's revoked, it's stayed, and they're placed on probation for a number of years. That's what a probationary order looks like. The next model order is public reproval. And that is the lowest form of discipline you can impose. So if you're looking at a scale, this is like a scale of 1 to 10. This is a 1. This is sort of a letter of reprimand, kind of like that type of thing where we just say, you know, you violated, but we're just going to issue a public reproval here to let you know that we know there was a violation, but it didn't rise to the level where we felt like we needed to restrict your license and your practice. So, but it is discipline. It is a statement that you found an issue. So then the next is surrender in lieu of revocation. So sometimes your cases, instead of revoking, they may decide maybe perhaps they need to retire or something, or they've got a disability issue, they can't practice and they just want to surrender. And this is what that would look like. The surrender we would impose would be on the license lookup would just say surrender. But if they wanted to come back and practice again, we would treat it like the license had been revoked, so that they would need to comply with the same terms and conditions that someone that was revoked has to comply with. So that's what this says right here. And then we have options for petitions for reinstatement, so that when you go into closed session and you have a petition for reinstatement, these are your options and you know what they are. My experience has been with boards that if there isn't a list somewhere, it's a lot more work to try to put these orders together. So I think having the list of what your options are on a petition for reinstatement will make your job, I hope, in evaluating petitions for reinstatement easier. And again, we've had problems with judges knowing what the options are as well. So putting in the guidelines, I think, will help, hopefully. That way, you know, your counsel can just point to that when you're putting your decisions together. So let me see, go to 61 if you wouldn't mind. Thank you. So again, we talked about, the first one was granting it. The second one was granting it and placing them on probation. So again, this is someone that's been out of practice due to discipline or surrender. And then here's that condition precedent I spoke with Dr. Mountain about here. So this is how the order would look when you want them to complete the condition first. And the types of conditions we impose can vary depending on your case. So it says a petition is granted, reinstated upon completion of the following conditions precedent. So again, the condition has to be met first and then the license issues. But examples would be, for instance, perhaps they owe restitution to a consumer, or they owe cost recovery, which is a frequent issue with people that are reinstating. They have not paid the cost recovery they owe you. You want to make sure that gets paid before you put them back into practice. Completion of continuing education. Perhaps you felt like you really hadn't shown enough rehabilitation on competency and you wanted to take some continuing education. Maybe you wanted to take a physical exam, complete a rehabilitation program, and again, take and pass a licensure exam. Again, these are just ideas for things that you might want to use in a petition for reinstatement. You are more than welcome to make up your own conditions based on the facts of the case, but we were just trying to give you some guidance here on the types of conditions you might want to place on a reinstatement. And then we go to petitions to revoke probation. It's the same process we just went over for reinstatement. So let me go to 62 real quick. Okay. And then, extension of probation, that is an option that's slightly different here. There may be situations where the board, instead of revoking the license, wants to extend the probation, even though there's been a violation, because perhaps there was mitigating evidence. Again, we talked about mitigation evidence that allows the person to consider extending the probation rather than revoking the license. And then finally, we have applicants. So again, applicants, when you see a statement of issues, that's your clue that this is an application. This is someone has not been licensed yet, but that staff have identified grounds for denial or disapproval of their application. And that was either settled or litigated in a hearing. And then we're at a decision point, and these are the orders that you potentially could issue. Maybe you found like you didn't think they needed to be restricted. There was enough rehabilitation evidence and you want to grant it with no restrictions. The second one is, well, there was some rehabilitation. They're safe to practice with restriction until we're convinced they're completely rehabilitated. Then you'd place them on probation. And the next screen, please. Then again, you have an option for doing a condition precedent like we have for licensing applications, for licensees, you have the option to complete the condition first or complete it later. We have that language here in case you want to do that. And then if you just think there's no rehabilitation evidence submitted or they cannot meet the qualifying criteria for the license, then you just deny it. And that's the order. That's what the order looks like. And I think, like I said, that you would think everyone would know how to write them, but in my experience, that has not been the case. So we want to make sure we have consistency with how your orders issue so that there's no confusion about what the board's intent is. We've had situations where the board tells the judge to write it one way for a petition hearing, and we get an order that doesn't say that. So we want to make sure that whatever your will is correctly reflected in an order, whatever option you pick, that it does what you intend. And that's why we do the model orders. So people, when you've decided what track you're going to go down on an application or a licensing accusation for a licensee, that that actually gets implemented correctly. Any questions on this part? So I think, the rest of the guidelines, the staff have updated and revised some of the standard terms and optional terms and conditions of probation. We've also updated the uniform standards consistent with changes that were made by the Substance Abuse Coordination Committee, which is the committee charged by law with implementing the standards for the boards in the department. We have to follow them exactly. We've made those changes. So those are kind of the big ticket items. Is there anything else since I've been talking that you want to go over that you saw in the memo?
Would this be a time that we call for public comment?
Well, if you wouldn't mind, I'd like to ask for a motion before we go to public comment. Is that okay? Or do you
Okay,
want to
that-
go for public comment first?
No, thank you. I appreciate that idea. And can we call for a motion at this time?
If
Sure,
possible,
page
could we,
6. Sorry.
if possible, could we pull up page 6 of the memo? The recommended motion is motion A. And just to be clear, we're on agenda item 4B1. Thank you.
Page 6 is shown on the screen. If you don't see
You can go
motion
to
A,
the
please
bottom.
scroll down.
Can you see it now?
No.
It's at the very bottom of page.
Each individual person has to scroll down to see the motion A at the bottom of the page.
Thank you, Rebecca.
No problem.
So if you have no changes, the motion would be to approve the proposed regulatory text and incorporated guidelines for sections 2524 and 2579.10 and submit the text to the Director of the Department of Consumer Affairs and the Business Consumer Services and Housing Agency for review. And if no adverse comments are received, authorize the executive officer to take all steps necessary to initiate the rulemaking process, make any non-substantive changes to the text in the package, and set the matter for a hearing if requested. If after the 45-day public comment period, no adverse comments are received and no public hearing is requested, authorize the executive officer to take all steps necessary to complete the rulemaking and adopt the proposed regulations as noticed for 16 CCR sections 2524 and 2579.10.
John Deerking would so move.
Melvin Nieblas would second.
Ms. Neeblis, did you make a motion?
I made a second to the motion.
Yes, thank you.
I think Mr. Deerking made the motion.
He did.
And now we can
And-
take public comment on.
Thank you. Can we open it up for public comment, please?
This is the moderator. The Q&A panel is open. If you'd like to comment on the motion before you, please click on that Q&A icon on your screen, type the word comment into the text box and submit that to our panelists. If you're a call-in user, you may also raise your hand by dialing *3. As a reminder, each commenter will have a time limit of 3 minutes, and I will provide a 30-second reminder before your time expires. And I'm not seeing any requests for comment at this time, either through the Q&A or hand raises. Would you like me to close the panel?
I would. Thank you so much. And I believe now we do a roll call vote. So Ms. Brown,
Yes.
thank you. Ms. Carpenter,
Yes.
Mr. Durking,
Yes.
Ms. Guzman,
Yes.
Mr. Hill,
Yes.
Mr. Maxey,
Yes.
Ms. Moore,
Yes.
Ms. Needless,
Yes.
Ms. Sonson,
Yes.
and I'm Carol Mountain. I also vote yes. It is carried unanimously.
Thank you.
It looks like there is another item under enforcement.
There is. There is.
Is that Ms. Wood or Mr. Maxey?
It's still Mr. Maxey, and but before I go on to the final item that I wanted to provide to my colleagues, I just want to commend Ms. Wood and her team for all the work that they're doing. And Ms. Woods, I think you do have a report you still wanted to make, correct?
I do, yes, please.
Absolutely. So why don't you go into that, and then I'll complete it with my final thoughts on the enforcement outreach.
Perfect. Thank you so much, Mr. Maxey.
Absolutely.
So everyone does have the Enforcement Division report and the stats. Does anyone from the board have any questions on that?
I don't, but I just got a call from my boss. I need to step away for an hour and be back. I apologize, board members. This is Nelly Nieblas. But I will be back in an hour. I apologize.
Thank you. Go ahead, Ms. Wood.
Right, so it sounds like we have no questions, so I'll go ahead and go over the enforcement cost savings. So as discussed at prior board meetings, the Enforcement Division has implemented several cost-saving measures. This includes changing the licensee applicant case review unit or LACRU from staff service analysts to program technician 3s, turning a staff services manager 1 into a special investigator and an AGPA into a special investigator. The cost savings for the SSAs to the PT3s will save an average of $6,500 per month. The additional SIs have allowed the Special Investigations Unit to take back 108 cases from the Division of Investigations. Since it costs approximately $220 an hour for DFI to conduct the investigation, the BVMPT has saved over $440,000 as today. The Enforcement Division is committed to finding and implementing additional opportunities for cost savings with the Enforcement Committee. Does anyone have any questions?
No, but great job and thank you so much.
Well, thank you. The Enforcement Committee has been very supportive of our actions and we really do appreciate it. Thank you so much, Mr. Maxey.
No, thank you, Ms. Wood. And again, thank you for all the work that you and your team are doing. And I want to conclude this with the enforcement outreach substance abuse PSA, which we're also really excited that we were able to conduct this and make this happen. And so as we discussed in prior board meetings, the Enforcement Division is working on an outreach in an effort to keep licensees from having to participate in the enforcement process. This included sending out an email reminder before Christmas and New Year's about intoxicated driving, updating the website to include more information about the enforcement process, and working on new PSAs. The next PSA will be on substance abuse. The proposed draft script is included in the board meeting materials for your review. And the next anticipated PSAs will be licensees and enforcement process, as well as probation, licensees' roles and responsibilities. That concludes my report. Colleague, is there anything else that you would like to add to the report at this time?
No.
Okay, thank you very much, Ms. Mountain, Chair Mountain.
Thank you so much. And thank you for your work on the public service announcement. I really appreciate reaching out to our constituents. I think it's very, very important. I believe we are ready to move on to agenda item 5, public comment on items not on the agenda. Note, the board may not discuss or take any action on any item raised during this public comment section, except to decide whether to place the matter on the agenda for future meeting pursuant to Government Code sections 11125 and 11125.7a. Can we ask for public comment at this time, please?
Thank you. This is the moderator. Our Q&A panel is open. If you'd like to make a comment for items that were not discussed on today's agenda, please click on that Q&A icon Type the word comment into the text box and submit that to our panelists. For our call-in users, you may dial *3 to raise your hand. And if anyone else has trouble finding that Q&A box, you can also raise your hand by clicking the hand icon that appears when you hover over your name. I'm not seeing any requests either through hand raises or through the Q&A panel. Would you like me to close it?
Yes, thank you so much. Mr. Swenson, let's see, I just read about the board convening in closed session, and then we say the open session is adjourned, and then we can go straight to our closed session, correct?
That's correct. You can retire to closed session after making that announcement, conduct the closed session, and then adjourn for the day without reconvening open session.
Thank you so much. The board will convene in closed section pursuant to Government Code Section 1126, Subdivision C3, to deliberate and vote on disciplinary matters. I would entertain a motion to allow the board to close the session and then to adjourn without opening the session again.
John Deerking would so move.
Thank you so much.
Abraham Miller, second.
Thank you so much. Mr. Swenson, do we need to vote on that?
Since it's formed as a motion, yes, and you should hear public comment technically, since it was a motion.
Right, can we open one last time for public comment, please?
This is the moderator. Our Q&A panel is open. If you'd like to comment on the current motion, please use that Q&A panel to submit the word comment, or you may also raise your hand. For our call-in users, you may dial *3 to raise your hand. And seeing no requests, would you like me to close the panel?
Yes, please. I will now take a roll call vote on the motion. Ms. Brown?
Yes.
Ms. Carpenter?
Yes.
Mr. Durking?
Yes.
Ms. Guzman?
Yes.
Mr. Hill?
Yes.
Mr. Maxey? Ms. Moore?
Yes.
Ms. Niebla stepped away. Ms. Sonson?
Yes.
And I'm Carol Mountain. I also vote yes. That means that the open session part of this meeting is adjourned at 10:13, and we will now convene in closed session.